We acknowledge the traditional owners of the land, the Awabakal people, and pay our respects to the elders both past and present. Australia's current legal framework provides limited recognition and protection of Indigenous materials. Currently, Indigenous arts such as paintings, sculptures, etchings and many other forms are protected under the Copyright Act 1968. Copyright is an automatic protection that arises when an original work is completed. Remember though, copyright does not protect the idea or story or technique behind your work, only the expression of those elements through your work. There is no requirement to register any work in order to be protected by copyright. Copyright remains with a work for the author's lifetime plus 70 years. During this time, an artist's family or nominated heir can benefit from the copyrighted work. If you wish for someone to benefit from your work after your death, you should consider specifying this in a written will. Copyright protects artists by preventing others from reproducing your artwork, communicating your artwork to the public, for example by making an artwork available online and publishing your artwork.
As a creator, you also have moral rights in any artwork you produce. Moral rights work in conjunction with your rights under the traditional copyright regime, and similarly they apply through virtue of the fact that you are a creator of an artwork. In other words, there is no registration regime for protection. Under the Copyright Act, your moral rights include the following: your right to the integrity of your artwork, meaning no one but you can alter your work in a fashion which results in harm to your reputation. Your right to have your work correctly attributed, meaning no one but you should be credited as the author of your artwork. And lastly, your right to attribution of authorship, meaning you have the right to be identified as the work's correct author. If you feel one of your above-mentioned rights have been infringed, you may be entitled to an order from the court requiring the infringer be made to stop, and this is sometimes referred to as an injunction. You may be entitled to an order from the court ordering that damages be paid, or a public apology. If you believe any of your rights under the current copyright regime have been breached, you should contact the Arts Law Centre of Australia. This is a free national service which has expertise in protecting Indigenous intellectual property rights.
A major concern arising from the protection of Indigenous materials is the originality of the work, as they are often derived from the Dreamtime. The case of Milpuru and Indafer 1994 addressed this issue and found that the Indigenous artists of related clans based their works on dreaming themes, which did impart skill, labour and effort, resulting in a new original copyright work. For example, if an Indigenous community paints as an unidentified group, there is no copyright protection available unless the group can be named and identified. If an Indigenous community tells its oral history and it is not transcribed, there is no copyright protection. If it is transcribed, the laws state that the writer owns the copyright, but of course it may not be the scribe's story. Copyright is one avenue for protection of works, however it does not protect Indigenous knowledge and custom. The only way to protect the original knowledge holder is to clearly specify it in an agreement. Unfortunately, Indigenous artists and culture are orally based and therefore do not meet the requirements of the Copyright Act and therefore are not protected. Further, sunset clauses associated with copyright mean that sensitive knowledge and cultural expressions could reside in the public domain against the wishes of the Indigenous custodians. This means that information or material is free for anyone to use. The requirements for disclosure, particularly through the patent system, presents one of the most significant risks for the protection of sacred and secret Indigenous knowledge. The disclosure requirement means that if an Indigenous person wished to protect their sacred material under intellectual property law, then they must disclose the sacred material to the public domain. Indigenous people are therefore rightfully concerned that the cultural works, information and knowledge that resides in the public domain may be misappropriated, misused, and used as a commodity to derive profit or commercial benefit. The Design Act 2003 also offers limited protection for communal intellectual property works. As with the Copyright Act, it offers only a limited period of protection, afforded only to the registered owner of the design. As a mechanism, this has significant limitations for people in Indigenous communities when compared with the Copyright Act, where protection is automatic on publication of the work of the art.
A comprehensive legal framework for the protection of Indigenous knowledge remains elusive, since most of the provisions for intellectual property law evolved out of westernised views of knowledge as a commodity owned by individuals, rather than a source of cultural heritage owned by communities. This can put Indigenous artists in a difficult situation, as individual ownership of cultural works may breach traditional or customary laws. The Bullen case is an example of this. In that decision, the court found a single author had a duty to his community to exercise his rights in a manner which protected the integrity of his community's culture. This places an extra burden on Indigenous artists when exercising their moral rights and further highlights the need for reform in this area.
In terms of how best to use the current legal framework to your advantage, here are some practical tips to help you better protect your artwork. Where possible, document your work. Taking photos and keeping all rough drafts goes to prove when you created a work and that your work is yours. Do not sign away your copyright to anyone, and especially without legal advice. Ensure any agreements to use your work are provided in writing. These can be used as evidence should later issues occur. Continue your working relationship with the Sydney Indigenous Artists Centre. Art centres manage copyright matters on your behalf and can enhance the protection of your work through their greater access to legal resources and copyright knowledge. If publishing your artwork online, start with low-resolution images. This limits the quality of an image available for others to potentially use without your permission. Keep images small. Smaller pixel counts print badly and when enlarged become pixelated and grainy, making them unsuitable for printing and reset. If possible, and depending on the artwork, use a cropped portion of an image rather than the whole. And finally, add a copyright notice and use a watermark across your work. There are examples on the screen in front of you. These reinforce that a work belongs to you and your copyright entitlements. Overall, if you're unsure of your rights, seek legal advice. Free legal advice tailored to Indigenous creators is provided by the Arts Law Centre, and all information is freely available on their website.